the Ordinance Committee meeting of April 19th to order, and if we could start with a roll call.
Councilmember Jordan.
Here.
Councilmember Oscar Gutierrez is en route, and Chair Sneddon.
Here.
Thank you.
Thank you. And do we have any members of the public wishing to speak on items not on the agenda?
Currently, no one is logged in for public comment for items not on the agenda.
Okay, thank you. With that, we'll invite staff presentation.
Thank you. Afternoon, Ordinance Committee, Councilmember Steiner and Councilmember Jordan. Assistant City Attorney John Doimus. With me today is Commander Kenneth Kushner from the Police Department, and we're happy to present the Animal Control Ordinance. I want to start off first apologizing for, usually we have our usual graphics for our PowerPoint. Today we decided for shock value to put some dogs that are owned by my colleagues at our office, our wonderful people at our office. I don't know how they can sleep at night owning these type of pets, but so it goes. And during the presentation, I will probably give a little tidbit about the dog while also explaining the actual ordinance too. So this is Miss Ostringer's dog, Taylor Ostringer's dog, King. King is more, snobbish than vicious, which, is probably worse, but the problem is we can't codify or regulate elitist dogs. So what are we amending today? Title VI codifies the entire city's regulations for animal control. It includes rabies controls, dog noises, vaccination, impoundment. It's been several decades, as I see up there, that's been amended. I think the last amendment that I was able to find was minor amendments back in 2000. A lot of them occurred in the mid-1990s. There were changes needed to codify when there have been issues of attacks of dogs, excessive noise, inadequate care, and rabies control. The police department does provide animal control enforcement for the city within the limits, while the Santa Barbara County provides the impoundment services and where we take the dogs and if they need treatment from veterinarians, et cetera. This is Leanna's dog, Daisy. Daisy is the first dog, I think, in history to ever file a excessive barking complaint due to other dogs. So she likes her sleep. One of the things we codified was addressing dog noise. We have for years, as a community service, our office, City Attorney's Office, and I've been involved in many of them, a lot of them could be contentious, have held dog barking mediations. And that's usually when we get together, neighbors who are complaining about dog bites, when dog barking, before there's any citations or any kind of enforcement in court. Usually we try to get animal control there, the neighbors and the owner, come up with a plan to reduce the barking, just to get cooperation with all the neighbors. We think it's important for neighbors to feel civil with each other. This ordinance wouldn't change that. We would still hold mediations when necessary. But the problem is we never actually have defined in our code what is considered excessive barking. So that's what we've done here. As you see there, it's barks or cries that are frequent and that affect 2 or more dwelling units. And the key for that is a lot of times the animal control officers do not witness the barking. They get called complaint and they come over, and by that time it's long ceased. It could be hours. So this way we rely upon at least 2 neighbors who are saying that their peace and quiet are being disturbed by this excessive barking. They would have to sign off on it. It's prudent for 2 reasons. A, it's pretty persuasive evidence for a judge deciding on this issue. And second of all, it prevents potential claims of retaliation. You have just 2 sets of neighbors coding, feuding on everything. So it's for the protection of that as well. So that's why we have that in the ordinance. And it's very common. A lot of cities would require 2 or more dwelling units to complain on that. This is actually my dog, Zeus, and I have nothing bad to say about him. He was a sweet dog. So passed away a couple years ago, but I had to get him on there. Also, we've decided to update our new vaccination requirements when an animal is acquired and revaccination. I'll explain, Ms. Heller is here as well, and she's been very helpful as we've gone over the ordinance and discussed proposed changes. One of the end is to ability to be added to obtain a waiver if vaccination would compromise a dog's health, and that waiver would come from a veterinarian. So there'd be revaccination 12 months after the initial one and 36 months after each subsequent vaccination. This is Sarah Connect's dog. Daisy is the one in front. The one behind I don't know, but you can just tell from the look in Rio's eyes, sorry, that was Rio's eyes, that it would cause, just sends chills down anyone's spine, so, but, and she's very prim and proper, which gets to our next thing, adequate care. We've codified the ability to hold people responsible who are not providing either adequate care or are basically showing irresponsible ownership. I have done some, dog hearings, and I'll get into that when we discuss dangerous or vicious dogs. Many times, unfortunately, those could have been prevented if the owner was more responsible or adhered to the warnings or restrictions recommended by the police department. And the key is recommended, because now we're going to mandate some, as I'll get into. So a lot of times that could be prevented, and there was no way to really ensure the owner would be legally responsible. So that's what we've done here, is to codify that, to not only that they have to ensure that the dog is being safe and following restrictions if it's imposed, for their own benefit, self-benefit, as well as we want to ensure that adequate care of the animals, and if an animal's not being taken care of in terms of where it's residing, the quarters, or unsanitary, et cetera, that the animal control officer has the ability to impound. This is Charlie, Michelle Sosa Acosta's dog. She just recently acquired it. Again, words just can't describe the level of terror of this animal. I dub it the Margarita Monster from its shirt. Also, what's worse about this dog is it's a fan of Jimmy Buffett, too. So that's the other thing. So this is the biggest changes we have done with the ordinance. Potentially dangerous or vicious dogs. We've created an entire new chapter. And we define what a dangerous or vicious dog. For a dangerous dog, we've defined it where on at least 2 separate occasions within a 36-month period, a dog engages in an unprovoked behavior that requires a defensive action to prevent bodily injury from a person or animal. The primary purpose of this is that usually if you have these attacks, it's also often a precursor to subsequent attacks. So it's step 1 in the process. And then a vicious dog would be one that inflicts serious injury or kills a person when unprovoked, or has been previously designated to be dangerous or vicious in the city or in another jurisdiction. And so that's how we've actually now have a true definition of this, because previously before, we would rely on the Food and Agricultural Code, but also we would have hearings, and sometimes the police department would send a recommendation letter. Okay, we recommend that you muzzle this dog, or et cetera. And then if another attack would happen, we would have another one and potentially be euthanized. So we decided to actually codify for the public benefit, also to make it more helpful for the hearing officer to follow such rules and procedure, to follow such definitions of what these are. And 622 also codifies the actual administrative hearing procedure. What would happen there is we would require a hearing officer, someone from the department who does not oversee animal control, so there's independence there. And it would not come to a cost to the city, because we're not paying for an administrative hearing officer. The police department would present their evidence. We would establish a record, and usually sometimes it's represented by someone from our office. Many times Mr. Way would represent the city on that. And if a dog is determined dangerous or vicious, or, for example, put restrictions on it, or ordered to be euthanized, unfortunately, then a person can appeal to Superior Court. That's the final level of appeal. There's no further appeal, and that's per state law under the Food and Agricultural Code. And normally what we do is we submit the record, the evidence, and the judge would review. It'd be a new hearing, but there would be great deference given to that record. So the judge would review the records, the case. There'd be testimony, and that would be the final process. So this entire code section outlines what the definitions are, the procedures, what's in the hearing, who overhears it, and the appeal process, and how many days you have for each step of the way. And finally, we also recognize that, if a dog, there's no incidents after a couple of years, a person can petition to a court, to the city police department, to remove the dangerous or vicious designation if there isn't an incident for 2 years or longer. And this is actually Commander Kushner's dog. I don't know how he trained it to smile so well. One of the biggest things we've done here in terms of the changes, as I mentioned, putting on conditions. So we have many conditions for dangerous and for vicious dogs. whether in terms of fencing a yard or maintaining its muzzled in public, et cetera. And these conditions are required to be adhered to, because before they were just recommendations in a letter. Now they're actually conditions imposed. And failure to comply with these conditions could result in filing of misdemeanor charges. We hope, the reason we're going this way, we hope that now with us being a little more strict and mandating such procedures, that it would even further reduce the need to have any of these hearings, because just as a preventative measure. Just so the committee knows, there hasn't been a huge explosion. The impetus for this, as I mentioned, is to just the need to update. There's been 6 hearings in the past 5 years. I've confirmed with the police department. And as I mentioned, the hearing procedures are in alignment with the California Food and Agriculture Code. Again, Teva's dog, bored out of my mind with my presentation and showing its elitist attitude, King. And I want to give a special thanks to Dr. Lee Heller, who's here, as well as other public commenters. I received about 5 or 6. A couple had concerns about requiring service dogs to be licensed and pointing out that we don't issue license. So we removed that requirement. We removed the definition of dogs that are trained for fighting from the definition of vicious dogs. We combined the requirement for sanitation or adequate care, so it's under one whole entire section. We also, as I mentioned, allow for a waiver for vaccination if it compromises the health of the animal. And then finally, because we released the public release on this about 2 weeks ago, and I've been working with Ms. Heller, and she's been very helpful in this process, that we're considering some more that we can I'll discuss and we can adopt. I think they make perfect sense, and to go forward to City Council and present the entire final ordinance with these potential considerations. One is that prohibiting potentially dangerous or vicious dogs from, if they receive such a designation, from being in off-leash dog parks, even on a leash. The reason it makes sense is, pretty evident that if they have declared to have such a disposition, that even on a leash it could cause problems when a dog is off-leash, coming up to it, running and greeting it. So we want to prevent that from happening. The second one's the 14-day period where we have currently in the ordinance. There's a catch-22 that Dr. Heller pointed out, that if they're impounded, how are they required to get vaccinated or licensed? So we're going to rework that language where if it's released, they have 5 days to provide proof of vaccination and license. Otherwise, that would be a misdemeanor. Before I get to the destruction of impounded animals, another one is signage on gates for dangerous dogs. So one of the restrictions imposed for a vicious dog is that the owner puts notification on his property or gate that their animal has been designated a vicious dog. So we decided it would make sense for a dangerous dog as well, since it has had at least 2 attempts to attack, whether it be another animal or a person. And then we're kind of, Dr. Heller pointed out to me that the impounded animals, it's the destruction of it's I guess archaic. A lot of cities have moved away from it on this, especially for what the designations are in there for old animals, everything else. And I've confirmed with Commander Kushner that there is no cost to the city. We have a flat rate with the county in terms of impoundment. The cost is more for medical expenses, so I'll be working with her on that to update the impounded language with what's our current practices. And those are some of the major changes. There may be 1 or 2 else in terms of confirming vaccination, and that concludes my presentation. I just open to questions. The final 2 dogs, one is a Monday Fitzgerald dog. Again, she opposed anything I have to say during this presentation, so she wanted to be on the record. And the other dog is Tom Shapiro's dog, Emma. Emma passed away a couple months ago. I have nothing but wonderful things to say about her. She just liked to always attack my socks or feet, and that's it.
Thank you, Mr. Doimus. Do we have questions from committee members? Councilmember Jordan.
Thank you, Madam Chair. I'm going to work through your slides in a couple seconds, but first question, because I never really know what to say, in my district on social media or on Nextdoor. There's a lot of chatter at Douglas Family Preserve or East Henry's, And so could one of you go over what is the city's role or in the event of a dog that's going to qualify for one of these characterizations or for a dog bite? What service does the city provide in that particular occasion that a resident can avail themselves of, and how do they do it?
Sure. Councilmember Jordan, committee, I'll go into it, and if Commander Kushner has anything to add. So to clarify, what happens in the situation if a person complains about they've been bitten by a dog or their animal's been bitten by a dog? Okay, perfect.
Or just maybe not even a bite, but at the beach or Douglas Family Reserve, a dog running out of control and just not being under control. Maybe it doesn't rise to the level of a bite, but clearly just causing a ruckus because it's an antagonistic or ornery dog.
Sure. So I'll let Commander Kushner answer the second part. I assume it'd be calling animal control if there was worried about a dog being unruly and potential. But if there was a situation where a dog does attack and lunge but doesn't actually bite but is aggressive or it requires a defensive action or there's a
That would
bite.
be my word, I'm sorry. Aggressive
Yeah.
would be the word.
Yeah, we would, animal control would be called. They would, obviously in a case-by-case basis, what would exactly happen, but they would, cite the person, get the information, and based on these standards, if there's a need to, if they have a record of it being, a second time they've gotten called on this in 36 months, depending on what this ordinance has, they would require such designations to be placed if it was dangerous. If it caused a bite, especially a severe one, in that case, the dog would be, impounded, and of course, the owner giving notice of appeal, and we would have a hearing. And again, the hearing officer, depending on the circumstances, could anywhere put restrictions on it as we codify the ordinance to try to prevent something from occurring in the future, or could euthanize it. But if it's unruly, I would assume that usually that, I know we don't have that many animal control officers, but they would be called to the scene. And okay, I'm correct on that.
I'd like to add to that, if I might, Chair and Councilmember Jordan. In reviewing this, the Parks and Rec Department expressed concerns about just the issues you identified. So at page 4 of your ordinance, I rather overtly plagiarized a concept called voice and sight control. And I plagiarized it from the city of Boulder, where their Open Space and Mountain Parks Division, which includes open space and mountain parks, in a real traditional sense, requires voice and sight control training. So this definition is something that you could give your constituents to very explicitly express how they have to be able to manage their dogs when they're out on open space.
And so the voice, and because I was just continuing to think aggressive's not the only issue I think I hear about a lot, or see down at the Wilcox. It's, there's obviously people of dog people down there, and there's not dog people down there, and there's actually kids down there, and there's actually very old people down there. And so a large dog out of control can also cause a great amount of damage by running somebody over from the backside of them. So that would be the voice and sight control part, right?
That is correct.
Okay, perfect, thanks. And then that call would initiate with police or park rangers for help. If everything lined up and all the parties were still there and the world stopped and somebody was actually able to get out there at the right time, is that a call to 911 or dispatch, or is it a call to Parks and Rec?
It would, Councilmember Jordan, it would go to animal control, so it would go to police if that would happen.
And then, so if I could just ask a couple questions on the slides, on the addressing the dog noise one. There's nothing I don't like on all these slides. It's just the devil's in the details, particularly the dog pictures. But one of the components of the definition was a period of time. Is there not a good reason to define that period of time, to say 30 minutes, an hour, 2 whatever? I mean, everybody's got a different threshold of a period of time. You might be a working nurse all night. So a period of time of 15 minutes, every hour might be their period of time. For somebody else, it's just a couple-hour annoyance or all-day-long annoyance. So what are your thoughts on that?
Sure. Councilmember Jordan, Commission. You're right, everyone does have their different standards. And the reason it's not there because we didn't put a period of time is, my concern is it would make it harder to prosecute, right? That if we put in a 20-minute time limit, and then they'd be arguing whether it's really over 18 and 20 versus getting to the crux of the issue, which
Okay.
the animal control wants to hear and a judge would want to hear, like, you're going by the reasonable person standard, so.
Fair
you know.
enough. That was the word I had down there. What's the reasonable bar? So that you've decided that's it. And then I'm going to slide 9, ensuring adequate care. And so I'll just confess, because I know this thing has been a piece of clay being molded right up to this moment, so I have not read the exact ordinance, either version of it that you put in front of me. But I don't see anything in that second bullet on conditions at home. Where does that come into play, and is it so you define, I like that it's the guardian, not the dog, really appreciate that throughout this whole thing, but, so obviously running loose, bites, continued dangerous or vicious, but where is the guardian held responsible for conditions at home? Say a dog that's just chained up for a week at a time outdoors, or malnourished or mistreated, whatever that may be.
Sure. Councilmember Jordan, committee, first, the goal of having at least adequate care allows for an animal control officer to see a dog being mistreated in poor care, to impound it, and potentially to cite the inadequate care for that. When you have true, like a mistreatment where a dog is like chained up, abused, there are California Penal Code crimes for that, and that's usually filed with the district attorney's office. I've seen those cases
So
filed.
that's where it's,
So that's where you
those
see.
examples are kind of spelled out?
Yes, and that's
Okay.
where you see those as being prosecuted by that office. This gives us some ability to address, but more importantly, to impound the dog as well, but further criminal penalties can be imposed through the district attorney's office.
Okay, then on the potentially dangerous or vicious dog slide, I think I was kind of cheating when you were going ahead, and the packet that you laid up here that has some of the revisions on it, we're much more in line with the county language now than our own language, right?
In
On
terms
the
of the-
definition of vicious or
sure.
dangerous.
Councilmember Jordan, committee, a little bit more, I spoke with Ms. Heller, we generally like our definition. The county's definition has a lot of cross-references in it too, so it adds more complexity. So we've based ours, at least looking at a kind of a combination of the county as well as state law, Food and Agricultural Code to kind of come up with this
Okay.
reasonable definition.
And one of our considerations, of course, for somebody who does question that outside this area, outside the building, is that the county generally works in a scope of wider open spaces, more space between houses, more places to run around, control whatever. We are in a dense environment where whatever's going on is generally right on top of your neighbor too, right? So
Councilmember
that-
Jordan, yes, that's very accurate. And like I said, we do take consideration of the county and want to consider a lot because they do support us in this in terms of providing impound services. But, for clarity purposes, we wanted to be really clear, and that's why we provided the definition and encompasses all that you mentioned.
Okay, then last slide on that discussion, you're talking about a removal of destruction of impounded animals. If an animal gets that far, so I'm assuming what you're talking about is a vicious or dangerous dog or loose-running dog, and it's so bad that somebody has to impound that animal and take it from the party?
Councilmember Jordan, there could be various reasons, right? Could be just an owner moves or found a stray dog and everything else. So that impoundment language doesn't necessarily just deal with dogs that we've impounded due to dangerous activities. It could be everything else. And so what we currently have in the ordinance. We want to kind of change that to be a little, I guess,
And so-
kinder and gentler is one way to put
And
it.
so does the result of that also just enter the regular protocol for eligibility for adoption or not?
I don't think Councilmember Jordan, I don't think it has an effect on the
It's either
adoption.
way. Okay.
Yeah,
All
the
right.
county kind of sees that through. From what Ms. Heller told me, we actually, when it gets adopted, the city actually receives a feedback. So I'm not saying it's a money-making business, but it was an interesting point, so.
Super. Thank you. Thank you, Madam Chair.
Thank you. And Councilmember Oscar Gutierrez, questions?
Thank you, Madam Chair. I just had a question as to how much the fees or the penalties would be if issued?
Sure. Chair Stan and Councilmember Gutierrez, if you're talking about violations, for example, of anything, so it could be anywhere from an infraction, which may be several hundred, to a misdemeanor, so they're wobblers, and a wobbler is limited up to no more than 1,000 and 6 months in jail. So depending on it, these can be cited either as up to a misdemeanor, but it could be an infraction as well. So you're looking at several hundred for an infraction and up to 1,000 for a misdemeanor.
And this is just more of a general question, but how would this affect, our community of people of color and non-English speakers?
Sure. Chair Sneddon and Councilmember Gutierrez, I hope it has no effect in terms, like I said, we've had a very low rate in the city, something to be proud of 6 hearings where we had, severe situations, one of dog bites. I think the goal, the positive effect is to, versus before it was kind of no one knew where the rules were or where to go or what to see. Like I said, people would get letters and you wouldn't know how to appeal. At least this process now gives everyone knowledge of, okay, here are the rules, here are the regulations, here's a process, here's the definition, so it can be applied equally so everyone is clear. So you avoid any unintended impact or consequences like that. So that's one of the purposes I think that this is needed because it's made clear and it's applied to everybody.
I'd like to add to that response, if I might. I agree with Mr. Doimus. Another big move the ordinance is proposing that Mr. Doimus identified is removing the concept of dogs that have fighting dogs, that dogs or breeds that are were presumed historically to have a propensity to be vicious. So taking that out would prevent, in my mind at least, any connection to the ethnicity of the owners.
Thank you. And sorry if you did cover this and I missed it, but is there anything about the not picking up after the dogs in there?
Chair Stan and Councilmember Gutierrez, no, there isn't anything in that, or the ordinance about, I don't believe so, if I can recall correctly. I know I didn't add anything, I didn't review anything regarding that.
Is there already an existing law? Because I know it's just kind of common courtesy to pick up after your animal, but
There may be a penal code section. I'm never had to deal with the issue before. I'm not aware if it is or not, but it's under this ordinance.
okay. I just thought I'd ask. Okay, thank you.
Thank you. And then I have some questions. I guess my first question is, what is the source of this handout on our, okay, so I will comment on this starting now, that there are at least 3.5, 4 pages of additional text in there that we're scrambling to read, and it's not in the ordinance as presented today. I know you're going to, I see Dr. Heller wildly gesturing, and I'm sure you'll speak to it when you have public comment, but I'm going to say for myself to take these seriously, which I like to do. I'm trying to read it as fast as I can, but it's a lot of information that I'm not prepared to just approve today. So I'll start with that. Okay, so that helps answer too. And it is helpful if it says who it's from, because I thought maybe these were city attorney edits in the ordinance. Okay. So then just going page by page here, and I appreciate the presentation and the work done on the ordinance. And I just want to note, it is, you've made it a light-hearted presentation, but in my dog, we've had people with scars on their faces from being bitten by dogs, and my sister also rescues bait dogs, and we have a lot, I this is actually really serious.
No, I understand, I apologize.
I know.
Like I said, I've dealt with hearings where people have gotten attacked, and so it's a difficult subject. I just try to put a couple of cute pictures. up
Yes,
there.
no, and I appreciate that, and I just wanted to make note of, I know you take it seriously, and it's a serious ordinance. So I do have some questions. Page 2, and I'll just go page by page in here, sections where I can, but I was just, first one, I'm just curious, why so many definitions of fowl, and which kind of fowl, and pigeons or not pigeons? What is the sort of significance of that? Like, why do we?
Chair Sutton, back then, when a lot of these ordinance was like adopted in the 1960s, 70s, 80s, and 90s, I'm sure it was more prevalent there. We kind of left it untouched, but that's why it was nothing there. I just assumed it was probably something more prevalent or needed to be addressed back then. We haven't come to an occasion on
Okay.
this in the last year.
Yeah, once it starts getting into fancy pigeons, I think is when I thought, what, there must be a reason for that. Okay. So maybe we could consider, well, I guess it doesn't do any harm having it in there if it hasn't come up, but sort of while we're cleaning it up, maybe wondering about that. It's referenced a lot of places throughout the ordinance. So then page 3, and this goes into the potentially dangerous dog definitions, I guess. And there's the first paragraph under J, I'm sorry, it starts on page 2, that says, while not present upon the property of the guardian, and then the 2 separate occasions. So those are when the attacks are not on the property. But then that next paragraph says, when unprovoked, bites a person or otherwise engages in aggressive behavior causing a less severe injury than is defined in this section. I wasn't clear if that next paragraph was on the property or not on the property.
Sure. Chair Sneddon, that would be not on the property. So it would be a bite, because now you're taking it to a next level. There's actual bite, but it's less than what's defined as severe injury under the bottom towards page 3, number N.
Thank you. And then that next paragraph says, when unprovoked has killed, seriously bitten, inflicted injury, and then so on. My question there is, I mean, even if it's provoked, if a dog has killed someone, is this excluding that?
Chair Sneddon, so whether it's killed an animal, as you see there, it wouldn't be a person. That all depends on the circumstances of the situation. So even if that has happened, the police department can make a recommendation that it be deemed dangerous or vicious, and the hearing officer can decide. At least it gives an option, depending on circumstances, even if it's not obviously not a person, but another animal. And it all depends on the situation and circumstances. So there's flexibility built into that for the hearing officer.
Okay, and then what constitutes being provoked?
Being provoked, but for example, if someone truly trespasses, so not like a mail carrier going up to the yard dropping off a mail, but like breaking into the house, or someone trying to attack their owner, and the dog defends the person. Those are 2 of the most common situations I could think of.
And those are specific to on the property. So off the property, it doesn't, there's
Well,
not,
that would be off the property too, if it was unprovoked. For example, I'm jogging and someone tries to attack me, and my dog is, defending me as a person, then
Okay.
that wouldn't be considered a situation where, if it'd be dangerous or vicious.
and the reason I asked that too is to Councilmember Jordan's question about, say, the Wilcox property, or places where there are a lot of dogs off leash and there's someone jogging and a dog just runs up and bites the leg of somebody jogging. Is that provoked or unprovoked?
If, Chair Sneddon, if in that situation, again, it's fact by fact, but, I would argue in the position of at least the city, that if they're just simply jogging and don't make any action towards that person, and the dog lunges them, that's unprovoked.
Okay, thank you. And then again, on page 3, there's this section on racing or homing pigeons. I just don't know if it's necessary. I don't know. And then page 6, there's discussion of obnoxious behavior. And I was wondering what, how do we define obnoxious?
Obnoxious, and that's for adequate care. That'd be the smell, for example, where it would just be so strong that.
Oh, that
it
has to do
would-
with smell.
yeah.
Okay, so like noxious. Okay,
Correct,
thank
correct.
you. I wasn't sure there too, because I do know that chickens, I'll say I have chickens, and
Sure.
sometimes they're really loud, even though they're not roosters, so I was wondering about that.
No, that would, Chair Stein, that would deal with the adequate care, and they're just, the animals are not put in sanitary conditions, and the smell emanating from it just is cruel. You know, it's absolutely cruel.
Thank you. And then page 9 has to do with chickens and their coops. And I wasn't sure, does this mean that chickens can't, if an owner is present, can't be free in a yard? Or they have to be in a coop at all times?
Chair Stein, which portion of
I'm sorry,
page 9?
page 9, number 4. So it's 608010, under raising rabbits, chickens, and fowl. Number 4.
I see that. So it does, that code section does reference our zoning codes where it talks about where they will be located. So, you know, the distance between, for example, either schools, hospitals, or between a dwelling unit of 35 feet. It doesn't say whether they can be any, they can't be, it's silent as to saying whether they can be running free or not. It's just where the actual coop is located.
Okay, because it
That's what-
says all rabbits, chickens, fowl shall be kept in cages, hutches, or coops at
You
all
can-
times. Oh, which need to be clean
In
at
a
all
clean and
times.
sanitary
They don't
condition
need to be
at all times.
in the coops at all
Correct,
times.
clean and
Okay,
sanitary.
I'm glad I asked about that because I don't myself want to be in violation of municipal code. Okay, page 13, I think you answered this already about excessive noise. And I think I had the same question along those lines of, you know, on Nextdoor, that's like the biggest complaints that we see is neighbors complaining about neighbors and the excessive noise of their dogs. And so I'm wondering if this opens something up to neighbor complaints. I'm sorry, that's
Sure,
distracting.
no problem. Chair Sneddon, no, to go in the process, so like I said, there will be complaints from neighbors about excessive dog barking, and animal control does a wonderful job trying to mediate it and trying to like give recommendations to the owner to reduce the noise level. And if that doesn't work, then it comes to our office where we sit everyone down and try to come up with a plan together and give that owner time. And the reason why this is codified in here the way it is because, you know, it's up to the people who are being deprived. The animal control officer coming there is not going to really be able to testify or understand what's going on because many times they come up there, they're not hearing any barking, you know, by that point. So it's up to at least having two people. Basically, when you're issuing a citation and two people who are willing to sign it because they have to appear, tell a judge, this is unreasonable. Let me explain to you, Judge, why. And at 3 in the morning, I'm getting this, and they come out, you know, examples like that. And then it's up to the judge to realize whether, yes, it's excessive, it's unreasonable under the standard of this ordinance, and hold that person responsible.
I appreciate that, thank you. And then page 16, suspicion report to the county health officer. Well, I can't remember what my question on that was, so I'll move on to the next one. Oh, I guess what were the repercussions, but you answered that with Councilmember Gutierrez as well. So then a general question, we touched on it, but, you know, rescue of bait dogs or fight dogs, and so are those already at risk of being vicious animals, or do they start with a clean slate? Does it matter if it's transferred owner and living conditions? Just a general sort of statement about that.
Sure. As Chair Stenin, as Mr. Cullen and I, we changed the ordinance. We don't include any vicious dogs, so they're a clean slate in terms of fighting dogs, right? Even if they've been trained on fighting, they're not, you know, it's based on their actions. And so this ordinance, in terms of the definitions, predicated exactly on what we hope same people, how people are judged, right? What were his actions? Did he commit these kind of violations? And then the clean slate would happen is if, let's say, is deemed dangerous or vicious, but was not euthanized in this case, and there was no incident after 2 years, they would, ask for that designation to be removed, and that's where the clean slate starts.
Okay, thank you. And so that even if there's a change of guardian of the dog, it's the
Still-
behavior stays with, okay, with the dog. And then just one more general question about utility companies. And so say your dog is not great with people out in the world, you don't take your dog out in the world, you keep your dog behind a fence, dog doesn't leave, but someone from utility company enters your property. What, and there's an altercation with the dog, what?
Sure. Chair said, I guess in that scenario, it'd be very fact-based. That could be at least a defense of a person climbing unexpected that not provoked, but again, that's fact-based. That would at least be a defense for the person who owned the dog to argue it. So it all depends on the circumstances on that situation.
Thank you. So it's open to argument and interpretation. It's not codified here in this.
It's correct. That's what
okay.
the appeal and the appeal to courts for, to raise those points and issues.
Thank you. And then I guess I would ask, have you seen these edits?
Chair Sneddon, I did see some initially. I haven't seen the most. Yesterday I have seen some of them. So
Okay.
yes.
So then I'll ask you after public comment about 604070 has sort of many additional paragraphs, and then also 616010 likewise has a couple of pages. So I'll ask if you're ready to give an opinion on those, or if we wanted those considered, if we would need to wait and hear this again.
While we're waiting, if I might, Councilmember Gutierrez, Municipal Code Section 6.12.020 requires dog owners to pick up after their pets.
Madam Chair, can I
Oh, yes, Councilmember
comment to that, I guess?
Oscar Gutierrez. Or we're still in questions, but if you want to.
Oh, yeah,
Yeah.
if that's okay.
Yeah.
Thank you. So in that case, sounds pretty drastic, but like somebody could potentially call 911 to report somebody who didn't pick up after their pet, or how does that citation work?
Well, under Councilmember Gutierrez, under the municipal code, it is, the base offense is a misdemeanor. The prosecutor has the discretion to treat that as an infraction instead. And I would imagine that only in the most severe circumstances would we treat this as a misdemeanor, and if only for the practical reason that someone accused of misdemeanor has the right to a jury trial, which is more costly and time-consuming than this kind of offense would usually warrant.
Okay. And I also heard that there's a service out there where you could collect the droppings of an animal and send it to get tested to later then be identified. But from what I understand, that the owner of the animal has to willingly give this company those droppings so that it could be traced. So it's kind of odd that they'd want to be reported themselves. But is that kind of thing legal, that, as far as you know, as long as it's consensual on the owner's part?
I honestly don't know, I'm sorry.
Okay, thank you.
Thank you, Councilman Gutierrez. And we'd open up for public comment. If we could have Dr. Heller, please. We have one slip. Welcome.
And just to mention, we don't have anyone online who would like to make a public comment.
Thank you.
Chair Sneddon and committee members, thank you so much. I want to begin by thanking the City Attorney's Office and Mr. Doimus, actually, I will do this bravely, for being incredibly collaborative in this process. That's why there aren't any other animal people in the room, because everyone feels so good about what this is doing moving forward. And we spent 2 hours this morning trying to persuade the county not to charge the city more for its contract. So our energy's been trying to protect the city from cost increases. I feel very good about what's being recommended overall. I had some additional items proposed, and that's what's in front of you, and I apologize, my name wasn't on it. I thought I was going to be handing it to you. And some of this, Mr. Doimus and I have agreed we'll take on in the details later, and I had put stars by the things I thought were worth flagging. But we can skip number 2 of my notes. So the one thing that he and I need to work on, and he needs to talk to animal control about, is how rabies oversight is actually implemented, because as codified currently, it's not what the officers are doing. So the city needs to be protected from an ordinance that mandates a certain process that animal control is not doing, in case that discrepancy ends up being the basis for a legal challenge. And I know Mr. Doimus and Mr. Cologne can handle that. And I'm happy to give them input as to how it's actually handled, because I'm the one who often is present for that. The big issue going forward, and this is note 9 on the thing I handed you, is holding periods. So I'm comfortable with the potentially dangerous and vicious dog definitions and processes. They're not identical to the county, but they're so close that I think it's good enough. And although the county does handle a lot of what happens with potentially dangerous and vicious dogs when they're impounded, I think this difference is not significant. What is significant is that the city doesn't hold animals. When an animal is impounded, if it's going to be impounded off the property of the owner, as in the case of a potentially dangerous or vicious dog, it's going to be impounded at the county animal shelter. So we have this outdated set of rules about how long you hold an animal before you no longer have to hold it anymore. And the old rules basically said the city could then just destroy it, which is just not acceptable. There need to be standards for either adoption or return to owner, and there should not be an assumption that because an animal is old or ill, that it should simply be euthanized either. So I think we're in agreement about changing those, and then the real question is going to be, what do we change them to? Because currently, the county handles all of the impounded animals. And so you could simply remove these sections and not designate holding periods, but if the city, God forbid, decides to go with a different contract partner, I think we are going to want some language on that, and I'd like to work with Mr. Doimus on that, and hopefully come up with something that is similar to the county, because the county's is based on state law, what's called the Hayden Act, which was passed in 1998. And since the county's not charging the city more for a longer holding period, it doesn't hurt the city financially. So I hope we have your conceptual blessing to work on something like that, because I think it's really important that the holding periods give animals time to have options if they're not going back to their owners, and that there not be some blanket order that says, this dog is old, we're going to euthanize it because the owner didn't claim it. I have a backyard full of old dogs right now, and I love to take them. So what I would hope for is that we be working on some additional changes that we may not need to come back to this committee with. We can go straight to council with, unless we butt heads big time, and then I'll let you know, and come up with something that we can move forward with fairly expeditiously. Thank you. Do you have any questions for me, since we were in it for a long time?
I don't. Any questions from committee members?
Okay. Thank you so much. I really appreciate it.
Thank you. Thank you for your care, Dr. Heller. Well, with that, I would like to ask City Attorney your recommendations on that. If we did make these changes, I personally would like to see it back at ordinance briefly, but open to your recommendations or insights into that.
Chair, Standing Committee, I think, as Ms. Heller mentioned, we came into an agreement really quickly in a lot of these. Some of them, based on the timing, I was able to automatically, just based on her email, her notes, I was able to just agree and implement them without even a further discussion. I thought they were excellent points to make. Yeah, that's why we like opening up to the public for viewpoints on things. And then that's why I was able to make them in time for the hearing and the presentation. Some I wanted to have a discussion, so we met for a while to go over them. The biggest, I think we're in agreement with everything that's there, that's needed. Like I said, we're very close. As I mentioned in the slide, where we're going to make some changes like the noticing for dangerous dogs or et cetera. It was the impounding issue. Like I said, I don't imagine us to butt heads. We just need some more facts to make sure it's not costly to the city and to be, like I said, and to approach this in a very humane way as well. So I'm pretty confident that considering the changes left, that there really is no disagreement that we could make them and present the changes that from ordinance from today to council, that's very comprehensive. Get that everyone to in advance, and if there are concerns, we can always address it there, but I feel we're very close.
Thank you, Mr. Doimus, and thank you for working with the public to come up with an ordinance that addresses these issues. Did you have a comment?
So I have some comments, but just on that one, I don't want to kind of bog or not bog this down on people being uncomfortable about not really knowing what the discussion points are or how they're going to change. And so I was just looking at my calendar. I don't really see any burden on ordinance committee time coming up. So, I mean, I'd be fine with it coming back in 2 weeks on the 3rd. And I don't know how that affects this potential scheduling for council, but I don't imagine it should cause a big burden. Somebody will yell at me in a second if it does.
Well, I won't yell at you, but the 3rd is a challenge for us. Mr. Doimus will be leaving the next day to go to the league spring conference, so I would prefer a date after that.
Could it come back a week?
I do agree with him, though. I think the spectrum of issues, barring further discussion by the committee, is fairly narrow, but I'd respect your choice if you want to have it back.
Is the 26th too soon? In a week?
I think that would be a little too soon, yeah.
Okay. So the 10th, we already have an ordinance committee. I don't know what's on it. Ms. Grisanti, do you know off the top of your head?
I do. So on May 10th, we have the conversion of the 400 block of Anacapa Street to one-way to two-way.
Is that a pretty easy topic? I'm seeing a nod from the city administrator, so could we maybe shoot for the 10th? I mean, that'd be okay with staff?
And we can start that meeting at 12, just to ensure there's enough
Whatever you
time
want.
for both items.
My time is your time. Yeah, okay. And then, if it's okay, I could just make some general comments. And first, I'd just like to say, to me, it's a plus having somebody out in the community that is in the weeds on this stuff. And that's probably one of the reasons it's sat dormant for 3 decades, waiting for somebody to be in the weeds with us. So I think that's really good. And then also just generally, I think this is certainly the first time in our lives that we've been dogless. So in 67 years. So dogs are different things to different people, particularly dog owners versus not dog owners. And I think overall, what's being done recognizes that and helps define those relationships to each other, the dog owners versus the not dog owners, and in a more positive and beneficial way that helps both sides. If there's just 2 sides, maybe there's more sides than that. Particularly things I like about the presentation today is the inclusion of mediation, or the focus on mediation initially, the multiple neighbors that help to set a foundation for the seriousness rather than just making noise calls, one neighbor making noise calls, that it actually sets a foundation for the severity of the situation. And then overall, the focus on the guardian, not the dog, repeatedly, the guardian, it's not the dog. I like the more structured process and determination for dangerous or vicious dogs. Not that I really want to have a better way to determine that with a dog, but it better protects all the parties, both the owner or the guardian and the third party and the dog, from just falling into that trap because it's not structured and the people can't see how to stay out of that determination. And then last one, just I especially like the nuance of the potential danger or the potential need to control your dog even when on leash in an off leash park. Hear that constantly also, whether it's East Hendry's or the Douglas Family Preserve on social media, or people that just tell us when they're walking around with us. So those are things I think are great. I too, like, I think the rest of the committee haven't really had time to look through the handout today and figure out how you're going to reconcile that. So again, I'd like it to come back when it can, if that's the date that works, the 10th, and talk about what you continue to do and how you got there or how you can't get there. Okay? Thank you, Madam Chair.
Thank you, Councilmember Jordan and Councilmember Oscar Gutierrez.
Thank you, Madam Chair. I just want to thank the community members and Dr. Heller for the work and time that you put into this. And I think we can all agree that dogs and pet ownership is a very important aspect of our community and very well respected and appreciated. And yeah, I appreciate the efforts that you and city staff have put into this item. Thank you.
Thank you, and I will echo that and share that I have great appreciation for the partnership that you've created here and working together to make this a better ordinance. And it's because I value the work that you've done that I want to have the time to have that incorporated properly and to see it. But I do want to voice just support for these changes and looking forward to seeing it and looking forward to getting this updated to be a more humane ordinance. And thank you. Okay. And I think, I don't think we need a motion on anything today. Is that okay?
I just have is continue discussions and return to ordinance committee on May 10th.
I will make that motion.
Okay. So moved by Councilmember Jordan,
I second.
second by Councilmember Oscar Gutierrez.
Thank you.
We'll take a roll call
Roll call.
vote. Councilmember Jordan,
Yes.
Councilmember Oscar Gutierrez,
Aye.
Madam Chair Sneddon.
Yes, thank
Thank
you.
you.
And with that, we're adjourned.